Hi, everyone. This is Tanya Spivey with Real Estate Gals here with Chad Horner, lawyer at Curran Law Firm. And he practices exclusively in estate planning, probate, trust, administration. And we invited him because we wanted him to answer all your questions that may be coming up around estate planning, probate, trusts. So thank you so much for joining us.
Yeah, my pleasure, Tanya.
So first question that came up, specifically, I was actually talking with a friend, and she was really wondering, like, what's the difference between a trust and a will, and what's the most important thing to do?
Yeah.
Now that we have lots of time and people can maybe start the process.
Yeah, sure. So these days, with Corona, I get a lot of these questions, but even before that, there's a lot of questions about trusts, wills, things like that. And so I think the important thing for people to understand, there's all sorts of different types of trusts. Okay. So, and in my office, and my colleague, Stephen Mattis, we help people with those, types of trusts. But there's, some basic trusts that we do a lot of. For example, if you have kids who are minors or children, or if you have children who you don't want to inherit a lot of money, when they hit 18, then we can provide like a children's trust. We help people with that, and often we put that in a will. There's also types of trusts to reduce the impact of estate taxes, and maybe we'll get to that subject later. There's trusts for kids with disabilities, who might be on public assistance, and you don't want to impact that kids getting those kind of that kind
benefits.
Of assistance. Yeah. And then there's a larger type of trust that people, when they talk about trusts versus wills, what they're often talking about is a thing called a revocable living trust. Okay, so a living trust. And that's a little different than those type of trusts that I just referenced. So the idea behind a revocable living trust is that you put all of your assets into the trust. So everything it's a kind of a much larger instrument where you put everything into your trust. And then inside that trust, you can have a children's trust, a special needs trust for a kid, and other tax, trusts to help reduce the impact of estate taxes. So, but the idea behind that revocable living trust, which is what people are really talking about a lot, is it's really almost its sole purpose is a probate avoidance device. Okay. Because they've heard really bad things about the probate system and that they need to do whatever they can to avoid that.
Right.
And so fortunately in Washington, we don't have that bad of a probate system. And where people get a lot of this is from maybe friends and family in California or news coming from California, Susie Orman, people who are, broadcasting from there. Because in California, it's really good practice to create one of these trusts for everybody, or for most people.
Yeah.
So California lawyers, very competent, in that system, they're encouraging and they help people put together these trusts. But the majority of attorneys in Washington who practice in the area of estate planning and probate, we don't recommend that usually. Okay. So because our probate system here is not nearly, as bad and as expensive, as places like California. So that's when you hear about trusts, that's usually what people are talking about. And sometimes people need it, and I'll go through and talk to clients about the pros and cons of each option, but yeah, so that's kind of trusts in a nutshell, the basic trusts that people, come in for.
And what does like the probate system look like that, maybe scary, especially for some that maybe have gained assets because a loved one has passed, like just recently, and they don't know what to do. So maybe going through that, or somebody that may be close to getting assets that there's no will, maybe, or maybe there is a will.
Yeah, right. So so let's just take the bad example. In California, has a bad reputation It's an expensive process.
Yeah.
The court, supervises the process quite a lot. But here in Washington, the legal system, the court system takes a completely different approach. Instead of court supervision, it's kind of a notice state, meaning if you're going to start a probate, you have to give the heirs and beneficiaries all notice that you've done it so they can defend their rights if they have to.
Okay.
So the court's not going to supervise the probate. It's not going to intervene in probate unless somebody's screwing up. So if you're an executor who is not following the rules, sure, the court will get back involved. But we have this concept in Washington called non-intervention powers. So at the start of almost every probate, the court will give the executor non-intervention powers, meaning the court is not going to intervene and not going to supervise the probate as long as the executor or personal representative is what we call it, is following the rules. And so the idea there is that so the executor, as long as once they get appointed by the court, so the court will get involved at the very beginning to make the appointment. But then after that, the person now gets this kind of magical document called letters testamentary. So it's a one piece of paper that says that Tanya Spivey is now in charge of this estate. And so she can walk that piece of paper around to any person, company, institution that holds an asset of that decedent and show it to them along with a death certificate. And that person under law is required to, basically treat Tanya like it's Tanya's mom who's deceased.
Okay.
So
Tanya, taking those documents to the bank or to the mortgage company or... Yep. Okay, got it.
Yeah, and so the executor would need to, basically the idea behind a probate in Washington is not running back to court every time you want to do anything, okay, like maybe California. But here it's basically marshaling the assets. So Tanya is going to go to, again, the bank, a title company to maybe change or sell the house, contact a real estate agent to do that. Handle, whatever other assets that might be out there. So that's kind of the marshaling the assets part. The next part is making sure creditors are paid. So there's a process within the probate system, to make sure you've published a notice to creditors, if you choose to, take care of, and then handle all those creditors, properly. Again, court doesn't care as long as you're following the law and not messing up. Then you need to make sure the taxes are finally done. And then you just distribute the assets according to that person's will. Okay. And even frankly, if the heirs don't want to follow the will, like saying, well, we think Tanya should get more, technically they can do it, and the court's not going to care. So as long as all the heirs and beneficiaries are in agreement, then the court's not going to intervene in that.
So then, does that mean that someone creating a will, like what if they are really strong about, no, I really want all of my assets to go to the Schnauzer purebred rescue?
Well, yeah. So if there's I do a lot of those kind of wills where people want, charities, to be the beneficiaries. So they're charitably inclined, and that's great. And so we do include that in the will. So again, we're a notice state, so the court's not going to supervise it, but you presumably are naming an executor who is trustworthy, who's not going to take the money and run. But as long as the will is there and your executor is following the rules, the executor is going to give notice, to the Schnauzer charity, and they are going to now know, they're going to, hopefully have a copy of the will, or at least be able to go say, okay, hey, someone's given us notice that we're a beneficiary of this estate. So we need to figure out what we're owed. So the Schnauzer charity is going to make sure that they get paid. And now the Schnauzer charity can just say, well, we don't want it. And so, okay, that's fine. Then it would just go to the other heirs or beneficiaries in the will. Yeah. Okay.
And then if there is none, for example, someone only wants it to go to the Schnauzer charity, but they have children. And so the children could then essentially fight for some of that. Is that what
Yeah.
I'm hearing?
No. So
Okay.
let's say you name a charity as your
Hmm.
sole beneficiary of your estate, and you have kids. Okay.
Hmm.
So question is, who are you going to name as the executor?
Right.
Also personal representative is the legal way of saying that. But that person then is supposed to give notice, and and so they don't. The rule is you have to give notice to all of the
Okay.
beneficiaries in the will.
Hmm.
Plus, you have to give all the notice to all the heirs of the estate, meaning those people who would inherit if there was no will.
Got it.
Now, those folks can now say, "Wait, that will, she was not in her right mind when she did
Got
that
it.
will.
Okay.
So we want to challenge the will." Challenging the will is a really difficult proposition, as
Yes.
long as, if you have prepared a will and you've had an attorney help you with that, it really can be difficult. And you have to have
Yeah.
some real evidence of incapacity, or something fishy about the execution or the preparation of that will. But usually
Okay.
wills are upheld. You know,
Yes.
yeah.
Okay. Thank you for that clarity. And then, so can someone actually do a will themselves? Like,
Yeah.
legal zone or,
Yep.
um,
Yeah. So people often do their own wills. They can. It's certainly
mm-hmm.
legal to do that. It's
Yep.
not necessarily recommended. There's here. I mean, the I guess let me just tell you the problems I see, with homemade wills.
Yes.
I mean, the fundamentals of a will are fairly simple.
Right.
It's a document where you indicate how you want your assets to be distributed at your death. It needs to be signed by you, who is the person, who's
Mm-hmm.
the testator or testatrix. And then it needs to be witnessed by two people. Okay, so pretty simple, requirements of that.
Yep.
A couple of things that kind of become a problem, with that is if you ever need to admit that document to probate, you have to track down those two witnesses, and have
Okay.
them appear in court. So we don't want to ever do that. So
Mm-hmm.
what we do instead of that is we have the witnesses swear out a declaration or affidavit that they were there, and basically setting out certain factual, statements about the capacity of the person who did
Right.
the will, the fact that everybody signed in front of each other,
Mm-hmm.
those kind of requirements that a court might want to hear from those
Mm-hmm.
witnesses. So if you don't have that document, the will isn't going to help you at all.
Right. Okay.
Unless those, I mean, there's ways to get it admitted otherwise, but it's really hard. So
Mm-hmm.
that's a really important thing. I think a lot of the homemade LegalZoom things, they do have that, but it's really important to make sure it's meeting the legal requirements. The other thing I sometimes see in homemade wills is that they forget things, and like they say,
Mm-hmm.
okay, my house is supposed to go to Tommy, my car is supposed to go to Tanya, and then they stop there. Okay,
Mm-hmm.
wait, well, what about everything else? So
Right.
they miss kind of what's called the residuary clause. What am I
Okay.
supposed to do with all the rest of the stuff?
Right.
And then the final kind of thing I think that it becomes an issue is that the will is when you do a homemade will, there could be, especially on a deathbed or something like that, there's
Mm-hmm.
no questions of capacity, undue influence, things like that. And
Mm-hmm.
maybe there are going to be maybe allegations, especially if you're disinheriting a child, that one of the other
Right.
children, exercise some undue influence over the person at the time. So that's why, having a lawyer, if you can, it's really
Mm-hmm.
to everyone's advantage to
Yeah.
have a lawyer prepare it who's a completely disinterested third party.
Right. And who does it all the time, and what questions to ask, and
Yeah.
making sure everything is covered.
Yeah. One of the other important things I kind of want to point out too
Mm-hmm.
is that the whole estate planning is not just a will.
Right.
There's other things that really are important. So, sometimes a will is maybe one of the least important things. Think about our society today and most
Mm-hmm.
people. especially as someone who doesn't have a house, let's say, is an apartment. They have a 401k, an IRA, maybe a life insurance policy, maybe a bank account where they've named their mom as a pay on death beneficiary. Well,
Mm-hmm.
that person, if they've done the beneficiary designations right, everything's going to pass outside the will. Okay, so
Mm-hmm.
beneficiary designations are going to override the will. So the will is sometimes
Right.
not the most important thing to be thinking about in the whole estate planning, context.
Right. I love that you made that point.
Yeah. And there's one other thing I want to emphasize. I know
Mm-hmm.
I'm kind of getting astray here,
No,
but
I'm glad. These are really important tips.
because I get people in who, I mean, when people think of estate planning, a lot of them think, I need a will. Okay, I've
Mm-hmm.
already made the point. A will can be, fairly insignificant, in some
Yes.
people's estates. But some people, a power of attorney is the most
Mm.
important thing for them. So a power of attorney is a document where you name somebody, an agent or attorney, in fact, an agent, to handle your affairs, your financial affairs, or even healthcare affairs if you're not
Mm-hmm.
able to in the future.
Right.
So if you've done a will, that's great. But if you fail to do a power of attorney and then you become incapacitated, that can really cause a lot of difficulty, financial, administrative
Yes.
difficulty for your family. Let's say if they need to access a bank account or maybe sell your house, but you
Right.
don't have any capacity. Maybe
Mm-hmm.
maybe not just you're older, maybe you just had a car accident or something and you
Mm-hmm.
become incapacitated temporarily or not for that. There's a process that they can go through to called a guardianship.
Mm-hmm.
But that is an administrative difficulty that could have just been avoided by a piece of paper, just a power of attorney.
Right.
So that's another thing to really, I think, super important for people to keep in mind, when
So
thinking.
it sounds like that's probably number one, no matter what age you are, getting that just for fear. Like, what if you do get into an accident or something happens?
Yeah, yeah, yeah. It's really, the law in Washington. Let's say you have no will at all. Okay,
Mm-hmm.
so the will is nice. You
Mm-hmm.
name who you want to get your assets to. You're going to name your executor or your personal representative, and that's all nice. But what if you don't have one? Okay,
Mm-hmm.
then Washington law comes in, and it's called the law of intestate succession, and it spells out who's going to get your estate. So
Mm-hmm.
a lot of times, it's kind of intuitive. Let's say you are single with two kids.
Mm-hmm.
Uh, the law says your two kids get everything equally. Okay, if
Right.
you have no will. So you didn't have a will, no, not a huge problem. It's a little, inconvenient in the probate process, but not, overwhelming. Uh, so yeah, so a lack of will, you can get away with okay, sometimes, but a power
Right.
of attorney, and then you become incapacitated, that's a problem, for your,
Right. Yeah.
so
And your family has to go through all the steps.
yeah.
And sometimes it can be like time frame wise, right? Like that it can be an issue.
Yeah. Well, it's called, so if you don't have a power of attorney then, and you become incapacitated, and your family definitely needs to get to a bank account or needs to take some
Mm-hmm.
action on your behalf. The whole process is called a guardianship. And so, which is a legal process by which the court and your family, your court declares you incapacitated.
Mm-hmm.
It's very intrusive. It's administratively just, time consuming,
Lengthy.
emotionally for your family too.
Mm-hmm.
Mom or dad, have a guardian ad litem come in, visit everything, view medical records. The court views the medical records. Who wants that? I mean,
Right.
I don't want, everybody, in the court system looking at, your mom's medical records,
Right. Yes.
and then me having to sue mom saying,
Right.
Mom, I'm going to have you declared incapacitated. All of this could have been fixed by a
Just by,
power of attorney.
yes.
So
So,
sorry to
yes.
dwell on that, but it's a really important.
Yeah, I think it's really good to hit it home so people really understand.
Yeah. Yeah.
'Cause it's definitely not one that's talked about as much as like a trust or a will.
Right.
Definitely.
It's all the, total package, that you need.
Mm-hmm. Yes. And then just going back to probate, can you just share a little bit of what how long the probate process typically takes?
Yeah. So again, we're talking Washington. So
Mm-hmm.
it's pretty much it's driven the probate timeline is really driven by how long it takes you to acquire and marshal all of the assets of the person who died,
Okay.
take care of creditors,
Mm-hmm.
take and that's about it.
Okay.
So there is a creditor period. So if you do choose to publish a notice to creditors, which is recommended,
Mm-hmm.
you that is a 4-month time period. So the
Okay.
idea behind that is that if somebody dies, generally their creditors have 2 years to come after their estate. Okay. And so the creditor claim period is basically designed to shrink that 2 years down to 4 months.
Mm-hmm.
So you basically now, by publishing a notice to creditors, for any creditors that are out there that you may not be able to ascertain from just reviewing basic, information in the
Mm-hmm.
mail, then they're out of luck. Their 2-year period is shrunk to 4 months. They blew it. And so
Yep.
now you can, as long as you take care of all creditors that are known to you by just
Right.
looking at the mail,
Mm-hmm.
and you've published a notice to creditors, then you can safely close the estate within 4 months if you've already kind of marshaled all the assets, taking
Yeah.
care of that. Then you just distribute it out, follow the process, set out, in state law, regarding, distributions, of the
Mm-hmm.
estate, and then you're good. So timeline, if you're going to do a notice to publish a notice to creditors, 4 months. But
Okay.
really, especially now that we might be having some difficulty selling real property, going
Mm-hmm.
forward. Before, of course, as properties were just flying off the shelf.
Yes.
But going forward, we may be encountering a situation where the slowdown on the probate is going to be selling the house.
Got it.
So
Yep.
that, I says, in the past, I mean, I was doing this, 10 years ago, during the recession.
Mm-hmm.
That was what was really slowing down estates. But it's
Mm-hmm.
not, again, it's not the court system, that's
Right.
down.
It's
It's stuff that would have happened whether you had a will or a trust, it didn't matter.
right. Okay. That makes sense. Yeah,
Hmm.
that's great clarity. Is
Yeah.
there any other things that you feel like we should let people know that you may have had questions and like it comes up quite frequently?
The other thing that is kind of surprising to clients is tax issues.
Mm-hmm. Yes.
And so tax issues, many people think that when they acquire assets, get a bank account from mom,
Mm-hmm.
something like that, they have to pay taxes on this.
Mm-hmm.
And they don't, with certain exceptions. Okay. Number one, uh, tax deferred accounts, IRAs,
Mm-hmm.
401ks, where mom's never paid any taxes on that
Yep.
asset. Then, they do have to, when they inherit it and then they withdraw it, then they'll have to pay taxes on that, as
Mm-hmm.
they withdraw, just like mom would have had to do. The other thing is we have estate taxes. So the estate itself may get taxed,
Mm-hmm.
because, but the people who get it, they don't put it on their tax returns when they get the inheritance.
Okay.
So in Washington, is if you have an estate of more than about 2.2 million, Washington state will impose a tax, a graduated rate about 10% to 20%. So at the, so anything over 2.2 million, if your estate's worth that,
Okay.
including life insurance, by the way, is put in that.
Mm.
So you might have a $2 million life insurance policy, a young couple, and then suddenly they're bumped into a state tax,
Right.
but so, yeah, so any estate over 2.2 million will get taxed at the amount over the 2.2 million.
Okay.
Okay.
So if
So
it's 2.5, they're getting the 300,000.
of about 300,000. It's a little bit
Got it.
less than 2.2, but let's just use that
Yeah,
number,
just to make it easy.
round number. So yeah, and the other federal law though is right now at about 11.5 million. So
Okay.
you've got to be fairly wealthy to be
Mm-hmm.
impacted by the federal estate tax. So
Okay.
most of my clients, we're only talking about, concerns over the Washington state estate tax.
Got it.
And so so if somebody dies with more than 2.2 million, a CPA helps them out with a Washington state estate tax return, pays, some estate tax, and then distributes the remainder, to everybody. And that remainder would say get in their hands, they don't have to pay income tax.
Right.
So that's a common misconception that, people say, sometimes say, well, I got this inheritance, and so how much do I really get? Well,
Right.
you
Right.
taxes on that money.
Right.
Washington state and federal law does not impose a tax on that.
Got it. And they can learn more about what the taxation is through talking to a CPA, or would it be you and a CPA, essentially?
Usually a probate attorney, estate planning attorney, and a CPA.
Got it.
When somebody passes away, at least my office, we usually work in concert with an experienced accountant, can help with these issues as well. But we're certainly familiar with them enough to, get them down the road and
yes, give some guidance.
Yeah.
Right. That's great. Okay. Anything else you feel like burning questions that have been answered?
Those are a lot of the big ones. And so on probate issues, I have created a website.
Yes. I was just going to say, how can people reach you if they have more questions?
Well, one, I practice estate planning, probate, trust administration at the Curran law firm. We have a law firm in Kent. I'm a partner there. But I live in Seattle and work with Seattle clients as well. Up in the Seattle area. So, so just by finding me, the Curran law firm in Kent. For people who are curious about probates, there's a website I created that's used quite a bit in the state called kingcountyprobates.com. Many other counties across the state, recommend people view it. So it's not just King County, central, but it's called kingcountyprobates.com. And so that kind of it's kind of a guide, to the system, and answers a lot of questions. It's there, for fellow attorneys who don't practice in this area as much, but a lot of families, go there too to kind of get some initial information about it.
Yes, that's how I found you. I was searching, and it's jam-packed with lots of great information. Definitely. And we will include your information underneath this video too, so that, if they have more questions, want to start the process with getting their estate planning moving, they can definitely reach out.
Yep, I can help them. I've got a colleague, Steve Mattis, in my office. We both do the estate planning, probate, type of work. Our office is a kind of a full service office. There's other lawyers who do different things, but like real estate, business work, family law. But Stephen and I are just focused on this area of the law.
Estate. Got it. Well, thank you so much, Chad, for your time today. I really appreciate it.
Great. Yeah, happy to do it.
All right. Well, we look forward to anybody having questions to check in with you. Thank you again so much for your time today. Okay. Have a great rest of your day.
Yeah, best wishes to you.
Thank you.
Bye.